with resources, and we have to take a targeted approach.
Government bills. This council resumes the second reading debate on the registration of titles and land miscellaneous amendments bill 2025. Mr. Lau Kwok-fan, chairman of the Bills Committee on the bill, will first address the council on the committee's report. Mr. Lau Kwok-fan. Thank you, President. As chairman of the Bills Committee on registration of titles and land miscellaneous amendments bill 2025, I would like to report to the council on the salient points of the deliberations of the Bills Committee. The existing land registration system in Hong Kong is a deeds registration system. The purpose of the bill is mainly to amend the Land Titles Ordinance (LTO) and the Land Registration Ordinance (LRO) to adopt the new Land First proposal for the gradual implementation of the land title registration system so as to bring Hong Kong's land registration system on a par with those of other jurisdictions. The so-called new Land First proposal means that the system in which title register prevails will only apply to certain land granted on or after the commencement date of the Land Titles Ordinance, that is, new land. The Bills Committee held 7 meetings with the administration and heard oral representations from 8 deputations at one of the meetings. The Bills Committee supports the proposal in the bill to implement the land title registration system for new land first, which is an important step in Hong Kong's migration to the system. Having regard to the fact that Hong Kong has a vibrant property market and search services are crucial for the effective operation of the property market, members were very concerned about the transparency of the title registers under the new title registration system. Some members urged the administration to consider relaxing the relevant requirements to permit non-specified persons to inspect past records of a property if the land registrar considers the application reasonable. The administration explained that as it was established that historical records would not be required to ascertain title and that the records contain sensitive personal data, access to historical records would be restricted to persons to be specified in the subsidiary legislation. Specified persons include former property owners and persons who may have a genuine need to check historical records when discharging their professional duties, such as solicitors and accountants. The administration believed that the proposed search arrangement struck a reasonable balance between maintaining the transparency of the title registers and protecting personal data privacy. In the course of scrutiny, members expressed concern about the proposal to abolish the mandatory ratification rule in the bill so that a bona fide and innocent purchaser for valuable consideration and in possession of a property will be entitled to indefeasible title even when the property is transferred through the fraud of a third party. The former owner who lost their title as a result of fraud will be entitled to indemnity, which is subject to a cap under the Land Titles Indemnity Fund. Members consider it necessary for the administration to strengthen measures to prevent property fraud so as to enhance protection for original property owners. Members were also very concerned whether the duty of verification borne by solicitors in title registration applications under the new system would be heavier than that under the existing system. The administration advised that a series of legislative and administrative measures would be taken to minimize the risk of property fraud and reduce the burden on the indemnity fund. For example, applicants are required to apply to the court for a rectification order before they claim indemnity from the fund in case of fraud. The land registrar is empowered to make a rejection order to prohibit the registration of any disposition of a property if there are reasonable grounds to suspect that property fraud has occurred or is likely to occur. The Land Registry will also issue title certificates with various anti-forgery features to assist industry practitioners and purchasers in verifying the identities of owners. On solicitors' duty of verification in relation to title registration applications under the new system, the administration explained that except that solicitors are no longer required to check historical transaction records over the past years to verify the title under the principle that the title register prevails, the conveyancing process under the new system would be substantially the same as that under the existing system. In verifying the applications, solicitors are required to take reasonable steps to verify the applications. The Land Registry will issue the guidelines on verification requirements for solicitors to set out the general procedures to be followed in verifying applications in respect of general transactions. on the administration's proposal to increase the indemnity cap of the indemnity fund from $30 million, the figure proposed when the LTO was enacted in 2004, to $50 million and set the levy rate at 0.014%. Some members pointed out that the value of ordinary properties had at least doubled since 2004 and queried whether the indemnity cap of $50 million was sufficient. There was also a suggestion that different indemnity caps and levy rates should be set for different types of property transactions so as to provide sufficient indemnity protection for owners of commercial properties, which generally involve a higher amount of consideration. According to the administration, based on the land registry statistics in 2023 to 2024, the indemnity cap of $50 million will cover 99% of the property transactions, as it is expected that the number of transactions during the initial period of implementation of the new Land First proposal will be relatively low, with the number of commercial properties estimated to be even lower. It is therefore proposed to adopt a uniform levy rate and indemnity cap to facilitate publicity and implementation. The administration will assess and review the relevant arrangements in due course after the new system has been implemented. As regards the conversion mechanism for existing land, the Bills Committee urged the administration to actively study the relevant conversion arrangements and timetable. Some members suggested that the administration should consider establishing a voluntary conversion mechanism in conjunction with the implementation of the new Land First proposal, or requiring mandatory applications for conversion upon the first property transfer following the commencement of the amended LTO, so as to expedite the conversion of existing land to the new system. There were also views that the definition of new land could be broadened to cover land granted in recent years before the operation of LTO, but not yet divided into undivided shares and held in multiple ownership, for example, land with building works yet to be completed and uncompleted flats not yet pre-sold, so as to include existing land with no title problems notionally in the new system. Given that the bill sought to introduce a completely new title registration system, members urged the administration to conduct publicity and education campaigns before the amended LTO comes into effect. The administration advised that the land registry had kick-started internal research to assess the scope and types of problematic land registers among the existing 2.9 million land registers. And the administration plans to start discussing with stakeholders from 2026 onwards on possible conversion options. The administration will also revisit the options that have been considered in the past, including mandatory conversion upon the first property transfer following the commencement of the amended LTO, voluntary application for application. The administration will continue to discuss with key stakeholders to arrive at the most practicable conversion option. On member suggestion of broadening the definition of new land, the administration explained that while the title history of such land might be less complicated, there might still be registered interests. Taking into account the limited number of cases that would benefit from the proposed broadening of definition, it was considered prudent to adopt the definition of new land in the bill. The administration also advised that it would step up publicity and education efforts to enhance the understanding of the public and the trade on the new system, including explaining some important legal concepts under the amended LTO, such as impossession of the property, with the aid of easy-to-understand examples in relevant publicity materials. In response to members' views, the administration will propose a number of CSAs, including amending the proposed amended Section 66, the proposed new Section 67A, and proposed amended Sections 69 and 70 of the LTO to make it clear that a purchaser who enters into a transaction with a trustee, including personal representative or a trustee in bankruptcy, need not inquire whether there has been any breach of duty of the trustee in the dealing, and that the purchaser referred to in the relevant provisions must be without notice of any breach of duty of the relevant trustee, including the personal representative or trustee in bankruptcy in the dealing, in addition to the requirement that the purchaser must act in good faith and has provided valuable consideration. The Bills Committee supports the CSAs proposed by the administration. President, the following are my personal views on the bill. I am very happy that today I get the chance to express support for the bill. With the legislative amendments, it is since the enactment of Chapter 585 and negotiations and discussions with various stakeholders, we now are finally entering a new chapter. It is a milestone in the land registration or title registration system in Hong Kong to make sure it is up to date and provides solid foundations for economic development of Hong Kong. The deeds registration system was established in 1884, and it operated in accordance with Chapter 128, Land Registration Ordinance. This was a colonial era system. The main difference between the existing system and the new system is the registration of priorities of charges and titles. There is no certainty in the final ownership because there is no clear order or priority of registration. So there are potential issues. There may be a break in the chain of ownership, or there are multiple registrations. Owners may find it hard to prove their ownership. We have heard some owners that are so protective of their deeds, they rent deposit boxes to put their deeds, or they even have specific rooms in their premises to store deeds. It has cost great time and effort to check titles. And for every transaction, the process has to be repeated. There are also more disputes. When I follow the developments in new development areas such as new territories east and north, Kutong North, Fanling North, I have encountered many cases of some issues stemming from the existing system. They had to refer to previous legislation relating to new territories or even laws in the Qing dynasty to establish ownership. The situation can be quite complex, and according to the government statistics, the land registry provides certified copies of 99,000 titles. Only 3% of them involve assignment, but you can anticipate how much workload there is for the checking of titles. Even in the UK, New Zealand, or Singapore, they now adopt this land title registration system because it provides better protection for owners. It will also streamline the processes of verifying titles. It provides more certainty. Title records are irrefutable evidence. So replacing the deeds registration system with land title registration system will bring us up to par with the standards of other jurisdictions and provide a better business environment. This is a good policy initiative. I thank the Land Registry and Development Bureau for their efforts. They, however, have taken the approach of dealing with the simpler issues first before the difficult ones. There are some issues that have yet to be dealt with as a result. The Bureau pledged that 1 year after the implementation of legislation, they will deal with different issues. I have some points to make here. I want to ask, how can we expedite the conversion from the existing system to the new system? As I said earlier, the administration adopted the approach of dealing with simpler issues before the difficult ones. We have 2.9 million title registers. And if we focus on new private land, it may not be a lot. We need to really think about how to convert existing land to the new system. Members have raised multiple suggestions. I suggested that there should be a voluntary mechanism for conversion. When owners want it, why not? Or there should be some sort of mandatory implementation so that for new property transactions, the titles involved should be migrated to the new system. Or that there should be a timeline for existing system to be converted to the new and better system. Next, on the approach towards adverse possession, I am glad that the administration heeded the suggestion of mine of having the new land first proposal. They will no longer accept claims of adverse possession, but I would say the existing provisions of adverse possession encourage people to take over other people's land. And the Law Reform Commission actually said in 2012 that in order to better protect owners, there should be a notification mechanism. But then we talked about how the notification mechanism would only come into effect after the new land title registration system is implemented, so that with the implementation of the notification mechanism, the occupant, having occupied the premises for 10 years, the new owner will be notified, and it is only when the new owner has no objections within 2 years, the person in adverse possession can apply for adverse possession of the property. We have now blocked the pathway for new adverse possession cases, but will we implement the Law Reform Commission's recommendation on adverse possession for existing land at some point to prevent adverse possession, to better protect private property? Should we implement a notification mechanism as said, or will we have other options? I await the administration's answers on this. On land premium, we said at the Bills Committee's meetings that much land in the new territories do not have certainty about land premiums. Some lots do not even have clear boundaries because of lots charts. So there should be a timetable for surveying, comprehensive surveying in new territories, so that there can be more certainty for owners in new territories. This will also facilitate the development of the Northern Metropolis in future. The new system is an enhanced one and has resolved many issues raised by the trade before. It also facilitates the development of land in future. I hope that in future this new system can completely replace the existing system. I hope the administration can set out a timeline for the trade to be prepared. On adverse possession and land premiums, I hope the Secretary can look into the different issues. I also thank the Development Bureau, Land Registry, and Secretariat and members for working very hard to finally make things move forward after 20 years. I thank you all here. I so submit.
Dr. Chow Meng Kong. I speak in support of the registration of titles and land miscellaneous amendments Bill 2025. It involves two existing laws, including CAT 585 Land Titles Ordinance and the Land Titles Bill established in 2004. According to the administration, LRO, the Land Registration Ordinance, provides for a deeds registration system. However, it only covers the registration of instruments. It does not provide for titles certainty. I believe you have experienced property transactions, and you will have to prepare a box of titles documents. They include basic sales and purchase agreement and mortgage documents from banks, and also deeds of mutual covenants of the relevant building, the flat layout plan, and correspondence letters with the developers. Different stakeholders hold non-domestic residential properties as well as domestic ones. And for members of the public, these documents are very cumbersome. The government established CAP 585 to introduce a titles registration system. And to introduce the titles register kept by the land registry, and this helps complete the relevant registration system, and this is in line with the practices in other jurisdictions in the world. This also will offer greater protection for both parties in a property transaction. This is a great start. After years, we will finally put into operation the amended Land Titles Ordinance. After discussion, it is decided that the new Land First proposal will be adopted. For solicitors as well as representatives from the real estate sector and members of this council have listed out the advantages of this new system. We will stick to the titles instead of deeds under the system, and this will help solve a lot of conveyancing problems. And for new land, they will not accept adverse possession applications. I have one suggestion. No matter what, for the existing 2.9 million registers, there should be a roadmap for registration. This is to ensure maximum economic benefits. Understand that it will involve a huge amount of manpower and resources to deal with the registration of the 2.9 million land registers. Imagine 20 years ago there was no AI or big data analytics, and such a system was proposed. With the existing technology, we definitely have the conditions to streamline the administrative procedures. For example, the government could consider for new apartments or new flats or newly completed buildings, they can exercise or implement the new system. I understand that there are relevant testing and trials in the relevant sectors. For example, for building plans as well as the use of data, AI could be adopted. So this is totally doable. The land registry may consider adopting a cost recovery approach. At the initial phase, concessionary measures could be rolled out for those who voluntarily switch to the titles registration system. This will help popularize the system, and it will also save costs. Thank you. Mr. Andrew Lam. Thank you, Deputy President. Hong Kong is one of the few places and economies that still implements the deeds registration system. When there is property assignment, relevant historical records will have to be checked to ascertain titles and ownership, and this procedure is cumbersome. I was told by the legal sector that some lawyers have to deal with old papers with deceased insects' bodies. In 2004, there was already the Land Titles Bill, and it was proposed that we should have the titles registration system instead of the existing deeds registration system. We went through a very lengthy discussion and public consultation, but still we weren't able to reach a consensus. We need a mechanism to convert from the deeds registration system to the new system, and that's why this has not been put into operation for 20 years. This current term government is finally getting us out of the quagmire, and this deserves our commendation. The government is approaching the difficult issues first, and the goal is to, with a phased approach, replace the deeds registration system with over 180 years of history. This will provide for titles certainty and streamline relevant procedure. According to the Registration of Titles and Land Miscellaneous Amendments Bill 2025, there should be a definition for new land. I wonder what new land covers. From the word, it should cover newly completed land or newly granted land. From the face of it, it looks like there is a clear definition, but there are many things we have to clarify when we come to the actual implementation of the new system. So at the Bills Committee stage, I raised a lot of examples. During the deliberation, the administration gave clear explanation. First, the definition of new land covers those covered under the government leases, instead of land involved in assignment or conveyances. It depends on when the lease is approved or granted. If it is granted before the implementation of the registration system, it is not considered as new land. Many are concerned that if the new system is fully implemented, whether the unclear delineation of new territories land would be dealt with. The government said whether it is land exchange or newly granted land, there will be clear delineation and borders of new territories land, so there won't be any relevant disputes. The implementation of the new system will affect all future property transactions, so we have to be clear with the overarching principle, and we'll also have to consider the overall comments of the public. We have to ensure that when it comes to actual transactions, there will not be any problems with the procedures. In May this year, a public hearing was held by the Bills Committee to give a chance for members of the public to voice their opinions. Overall speaking, the government is going to adopt the approach of dealing with the difficult issues first, and we all support this approach. I have to thank the professional bodies, especially the Law Society, for providing their professional views. Without their views, regardless of how hard the government works, it may not be able to grasp the potential issues that may arise in actual operation. During the public hearing and the Bills Committee stage, the government took on board a lot of constructive advices, and it amended the relevant provisions accordingly, and this helps lay a good foundation for the government's work. Then the government will have to deal with the difficult issues concerning land. The Bills Committee urges the government to convert the 2.9 million existing land registers to the new titles registration system. This topic has been discussed for years. I, of course, understand the controversial part of it. For example, during the conversion, there might be errors or mistakes, and this may give rise to losses of relevant owners. I suggest that the government come up with a concrete timetable for implementing the system soon. Lastly, I'd like to thank the government officials as well as the Secretariat for their hard work so that we saw the smooth scrutiny of the bill. I speak in support of the Registration of Titles and Land Miscellaneous Amendments Bill 2025.
Dr. Teck Chi-yun. Deputy President, I speak in support of the registration of titles land miscellaneous amendments bill. This is an important approach. Right now, we make use of the deeds registration system. The system is plagued with issues. It does provide for the priorities of registration of instruments, but it does not guarantee ownership. So for property transactions, historical records have to be checked. It's very onerous. Land administration in Hong Kong is still lagging behind the mainland, Singapore, and the UK. They have more modernized land title registration systems. With the bill's proposals, we have several benefits. It will provide certainty in titles. It is less likely that a title can be defeated due to omissions in the records. It also provides a better business environment, simplifies the relevant process. It will help attract more capital in investment. It also prevents improper possession or occupation of the property or property fraud. This will minimize the chance of disputes arising from such problems. We also see the government implementing the measures gradually, adopting a new land first proposal to minimize the risk involved in implementation. I do appreciate the bill, but there are also some reservations regarding the bill in society. Some are concerned whether the indemnity fund can provide sufficient protection. The 50 million indemnity cap may not be able to compensate those who have very high value properties. Would that cover all their losses, such as in losses in profit, as well as assignment costs and reacquisition costs? So there is a principle for indefeasible title. One, the original owner cannot, through a rectification order, get the property back. They can only apply for indemnity. But for property owners that have great attachment to their property, will pecuniary compensation be enough? And the threshold is very hard to be met on bona fide and one acting in good faith being without notice of the relevant issues and arrangements. We also have a two-pronged approach. We will allow for existing land to be under the existing system still in future. So we need clearer delineation on the different approaches for the different land under different systems. We need to monitor the implementation to get more experience for our future arrangements. The society also has reservations about the tightening of inspection. It is only the case that non-specified persons can get access to such information. The legal sector and the media are very concerned. We have seen previously the media have been able to uncover scandals of senior officials based on these records. If we limit people's powers to inspect the relevant records, there is going to be a problem. We have seen before in 2019, with the RTHK reporter being prosecuted for checking records. In 2023, she won the appeal. The judge said that the government cannot exclude one inspecting the relevant records in good faith. With the change in the government's stance, there can be a widespread impact. If you adopt this approach in future, historical records cannot be accessed by the media. The media's powers to investigate will be limited. It affects public surveillance of the government. The Law Society also had reservations about the tightening of the inspection arrangements. The Law Society thought transparency is very important for the economy of Hong Kong. With restrictions in inspection arrangements, it may hurt the confidence of investors. I would have the following suggestions for the government. First, including the media under the scope of specified persons. The media have all along been important in safeguarding public interest. We should have the government allow media workers to inspect for the purpose of public interest. We just need to set a threshold of them being qualified reporters. We can also allow for exceptions in specified persons, say academic research bodies and NGOs can access the relevant records if they meet certain conditions. This will ensure transparency. We should also regularly review the inspection mechanism and make adjustments if necessary. The government should collect feedback upon implementation and, if necessary, make amendments to relevant legislation so as to safeguard public interest without sacrificing personal data privacy. President, we need to safeguard personal data privacy, but we also need to safeguard public interests. Without transparency, the impact can be negative. I hope the government can reconsider their approach to inspection arrangements and strike a balance between protecting personal data privacy and allowing public the right to know. Dr. So Chen-Wing. I speak in support of the Registration of Titles and Land Miscellaneous Amendments Bill. The deeds registration system has been in place for over 180 years. The process is very complex and there is no guarantee of ownership. It results in high transaction costs and disputes in relation to ownership. In today's economy, this is no longer accepted. Since its enactment in 2004, the Land Titles Ordinance has not been able to replace the existing system with the new land title registration system due to disagreements among stakeholders. We have some new proposals under the bill, and we can see the government has taken a pragmatic approach to have the land title registration system apply to newly granted land only. I think it shows the government's pragmatism in taking forward the relevant arrangements. With this, we can see greater efficiency in property transactions. It also brings Hong Kong system up to par with other systems in other jurisdictions. There are multiple highlights with the bill. We have first the principle of indefeasible title, providing greater protection for purchasers in good faith that should instill confidence in investors. There's also an indemnity fund to compensate those who have lost their titles because of fraud. There's an indemnity cap of $50 million. There will be a uniform levy rate of 0.014%. This rate is reasonable. Lastly, introducing electronic notifications, title certificates, and restriction orders to prevent property fraud at source. The government's approach is quite forward-looking, but I do expect challenges to be had with implementation of the bill. The government has taken the approach of dealing with simpler issues before the difficult ones, and they're only dealing with newly granted land first. But we have yet to have any specific plans for the existing 2.9 million land registers. The administration said they will have more changes in 2027, 1 year after implementation of the bill. But I think the government should make their plans clear early on to make sure we won't have too much time in which both systems apply. The deeds registration system has been in place for many years. Citizens, on the other hand, don't know much about the new title registration system. It is important that we do more in publicity to instill confidence in the public. For the different challenges, the administration should take the following measures. One, setting up a cross-departmental working group led by the Development Bureau and include Lands Department, Lands Registry, the legal sector, and other industry practitioners to set a roadmap for conversion so that we can have existing land successfully migrate to the new system. There should not be any delay. The administration should report their progress to the Legislative Council at regular intervals. I also asked the administration to review the operations of the new system a few years after implementation, including the use of the indemnity fund, how many fraud cases there are, and whether the public is satisfied with the arrangements, and make adjustments if necessary. Right now, there is great uncertainty in ownership. There are repeated registrations. The administration should expedite a census to be done and have a rehabilitation mechanism for titles so as to establish ownership as soon as possible. The administration also has to do much in publicity and education. Through publicity activities, we should be able to enhance understanding of the public, and especially industry practitioners, property agents, the legal practitioners, etc., to make sure there is coordination in the dealing of property transactions and to ensure compliance with relevant legislation. The bill is an important step we are taking towards a modern title registration system. I support the government's approach of being pragmatic in taking forward the relevant arrangements, but I also urge the administration to have a clear timeline for implementation, for conversion, and to resolve the different issues. I so submit. Thank you, President.
Dr. Wendy Hong. Deputy President, Hong Kong is one of the few places in the world where the deed registration system is still in place. Now, it came to force in 1844 when the Land Registration Ordinance was enacted. And under this system, purchasers will need to rely on solicitors to check the deeds to verify the title. The conveyancing process is cumbersome. It is also costly and it's prone to disputes. Most economies in the world have changed to title registration system. And under this system, invisible title is guaranteed because of the principle that the title register prevails. It simplifies the conveyancing procedures. In 2004, that's 20 years ago, we enacted the Land Titles Ordinance with a view to converting the existing deed registration system to a title registration system. However, the government was unable to forge consensus among key stakeholders. Despite being enacted 20 years ago, the Land Titles Ordinance had not come to force. We're now in 2025, and we now receive the Registration of Titles and Land Miscellaneous Amendments Bill 2025, which is a revision on the Land Titles Ordinance for the purpose of implementing the title registration system on new land, and that is land leases approved after 2027, in 2027 and thereafter. And meanwhile, a dual-track system will be maintained for existing land. There are views that this new system only applies to new land and that the definition of new land is too narrow in scope. But I think it is more important to take the first step, and that with greater public acceptance, we can then extend the approach to existing land. So I support the new land first approach. The bill also provides for the introduction of electronic submission of documents and electronic conveyancing so as to simplify the process and lower administrative costs. I appreciate these proposals. About conversion of the existing 2.9 million land titles after implementing the new land first approach for title registration system, it is a very controversial issue. There many disputes may arise as a result of this conversion. Now, on the whole, the new system will provide much greater guarantee to prospective purchasers. However, they may also need to bear the risk of losing title because of fraud. And this is the public's concern. And having discussed with the Bills Committee, the government has decided to introduce a system called the Certificate of Verification so as to provide greater certainty. The Law Society of Hong Kong will also promulgate guidelines on verification requirements with 49 clauses to reduce the risk of fraud and dispute in the conveyancing process. An indemnity fund will be set up and a levy will be charged. In the case of a bona fide purchaser being deceived in the process, he can apply for indemnity. In fact, the government should educate stakeholders as well as the general public so that after accumulating experience under the new system, we can expedite the conversion process. For smooth implementation, I have the three suggestions as follows. For the 2.9 million land titles on existing land, apart from adopting a voluntary approach, I actually proposed the following at the Bills Committee meetings. Whenever there is dispute taken to court, parties may opt for the new title registration system. Now, if no legal dispute is involved, then whichever system of registration could work. However, when a dispute arises, it gives us a very good opportunity to convert to the new system. So I hope the administration will explore this option and discuss with the stakeholders. The second suggestion is about land boundaries in the new territories. Now, at the Bills Committee meetings, surveyors floated different proposals. For example, a tribunal should be set up to deal with matters of land boundaries, and that a new unit of measurement should be adopted. There should be a departure from the DD system. This may not have any impact on transactions of new land, but it will expedite the conversion on existing land. I hope this will be considered by the government so that the sector will be prepared for the redemarcation of land boundaries for the implementation of the second phase. The third suggestion is about the use of technology. At the Bills Committee meetings, I felt that the administration failed to explain what electronic means would be adopted for the registration of titles. According to the Land Registry, inspection of electronic register is currently in place, and I propose a protect stance of the government, especially on the use of blockchain. The blockchain technology can prevent fraud since no changes can be made to the data, and it is also traceable. Of course, it relates to upgrading and transformation of the property market. We also need blockchain technology to be implemented throughout the process, such as e-contracts and e-certification. Technological advancements are taking place at great speed. We need to catch up. Using technology can help us save time and costs in the conveyancing process. The administration should try out blockchain technology when registering the titles for new land, and this can be further expanded to cover other initiatives. It will mean a lot to building a smart property network and building smart homes. Concessions and incentives should be provided to encourage the public to adopt this technology. On the whole, after introducing the title registration system, we will be able to substantially reduce the risk of fraud. It will also allow the public to enjoy simplified conveyancing procedures. There is also a likelihood that the legal profession will lower the costs of conveyancing as well, so everybody will benefit from it. It will have far-reaching implications on the long-term development in Hong Kong. It will also provide great guidance to implementing the system on existing land. I support this bill, and I thank the government, the Bills Committee, and key stakeholders for their efforts. I do hope that this system will become familiar among the public so that we can expedite the conversion process on the 2.9 titles on existing land. I so submit. Mr. Tony Chair. Thank you, Deputy President. As pointed out by many other members, Hong Kong is one of the few places in which common law is practiced, and the deeds registration system continues to be in place. Now, in order to maintain certainty of title and integrity of the legal process, purchasers of second-hand properties will need to rely on solicitors to check all the deeds and other documents that may affect the good title. This adds to the cost of conveyancing. And in the case of loss of documents or incomplete documentation, the risk of transaction will substantially increase. This will impact on the property price. It may also cause the transaction to be nullified. In 2002, the government proposed making reference to other common law jurisdictions such as the UK or Australia to adopt the title registration system. With this system in place, the new purchaser will enjoy indefeasible title as long as the title is registered, and the parties will not need to spend additional resources and time to trace all the historical deed records. This can help lower the cost of transaction and enhance certainty. Now, when the bill was scrutinized, I was chair of the Hong Kong Institute of Surveyors. I was also consulted. This bill proposes to take a progressive approach. The government will go for the low-hanging fruits first, and that the new system would only apply to new land. But some other parties, on the other hand, were of the view that the government should implement the system in full. That means the system should apply to both new land and existing land after a certain specified date. The Land Title Ordinance was enacted in July 2004. Many stakeholders, including lawyers, surveyors, and property agents, questioned the feasibility of the conversion of the system overnight. Now, the government understood the situation. The government consulted the sectors again, and then the matter was then dragged on for 20 years. At this moment, the LTO is still not in effect. Now the government is of the view that there should not be any delay. So after consulting the stakeholders again, the government would go for the low-hanging fruit and would apply the system to new land first. This is exactly what the Registration of Titles and Land Miscellaneous Amendments Bill 2025 is about. In the scrutiny process, many members of the council and stakeholders had strong views about the applicability of the system on new land only. Comparing to the existing the properties on existing land, the titles generated on new land would only account for a very small percentage. I urge the government to expand the scope of the title registration system as quickly as possible. After exercising prudence and adopting a progressive approach, it is hoped that the general public and the market and the sectors would become familiar with the new system, and that the new system can be expanded in scope. In fact, some common law jurisdictions adopted the title registration system decades ago, and yet these economies are still not able to apply the new title registration system on all land and titles. So you can imagine how complex the issue is. The administration already gave an undertaking that starting from next year, there will be a discussion with stakeholders about the phased implementation and conversion, including a voluntary system. President, the Bills Committee also discussed different scenarios such as the impersonation of a purchaser in the case of a fraud or a false declaration that the owner has authorized to sell the property. Now, these are fraud cases that happen even under the existing system. Under the title registration system, once the title is registered, the purchaser will enjoy indefeasible title. There are concerns whether the new system will increase the risk of fraud, and that even when the court has decided that fraud is involved in the property transaction, the innocent owner will still not be able to regain the title. On this issue, the administration has proposed an amendment. If it is proved that the original owner has knowledge of the fraudulent activities or has proved to have taken part in it, then there is still a chance that the original owner's title may be overturned. For innocent owners who are deceived, the indemnity fund provides compensation to them. The amount of compensation is capped at $50 million. A levy will be charged on each property transaction at a rate of 0.014%, and the amount of levy will be capped at $7,000. Some question whether this compensation cap of $50 million would be sufficient. According to the 2023 statistics, this cap would cover 99% of property transactions. So the government has struck a balance between the levy rate and the extent of protection. So I support the government's proposal. Still, the market is subject to fluctuations. I hope there will be a regular review on the levy rate. And usually, affected persons would engage a lawyer or a surveyor to help apply for compensation under the indemnity fund, and that the professional fees will be reimbursed as well. But this is only dished out on the premise that the application is approved. If this is not approved under the indemnity fund, the professional fees will not be reimbursed. Now, there are questions on this approach. Because professional fees and the property transaction are two different matters. Now, if there is a separate mechanism and that professional fees can be reimbursed regardless of whether the application is approved, that there could be cases of abuse, and I support this argument. Now, the crux of the matter is to combat fraud. The government should, in the first place, step up publicity and public education so as to prevent fraud. The government has undertaken to set up an LTO education committee. This will be followed by training materials and practical guides so as to prevent fraud from arising from the new title registration system. On the whole, I support the bill. I so submit.
Ms. Carmen Khan. Thank you, Deputy President. The deeds registration system has been in use in Hong Kong for about 180 years. We are one of the few economies that are still adopting the system. This does not provide title certainty, and the conveyancing procedures are cumbersome and costly under the system. In year 2004, the Legislative Council passed the Land Titles Bill, which replaces the title registration system. That means title registration will be the conclusive evidence. However, under the title registration system, a lot of implementation details had to be sorted out and no consensus was reached. It's been over 20 years now, and the bill still has not been put into operation. The government officials, as well as the LegCo members that took part in the scrutiny of the bill, they are no longer in their positions. There were so many implementation details that had to be overcome and sorted out. and they could not be dealt with back then how come the bill was passed? The government is now proposing the registration of titles and land miscellaneous amendments Bill 2025. The latest proposal is to adopt the new land first approach. That is to implement the new system on newly granted land first. Land conveyancing, registration, and the proof of titles has implications on the business sector as well as members of the public. I wasn't a member of the Bills Committee, but I have some comments on the bill. First, on the existing land registration system, there's a lack of a conversion timetable to the new system. The new system, as suggested by its name, is expected to be put into operation in the first half of 2027 for newly granted land. As for the existing 2.9 million land registers, they will stick to the existing registration system. I think the pace of conversion is too slow, but we have to make the first step. According to the government estimates, after the adoption of the new proposal, there will just be 25,000 new registration within the next 5 years. And that's a relatively low number. Some members of the Bills Committee shares the same views with me. That is to expand the scope of new land to cover more land under the new system. For example, for land that is granted just before the gazettal date or land with undivided shares could be covered. For example, for unbuilt or uncompleted flats, all these could be included in the new system. According to the administration, while the historical records for these lands are not complicated, there are already interests registered, and so they should be regarded as the so-called old land under the existing registration system. I hope that the administration will seek more solutions to address the problem. In Singapore and the UK, the titles registration system or a dual-track system has been adopted. So I wonder what kind of challenges we cannot overcome. There are many disadvantages to the existing deeds registration system. For example, problems concerning safekeeping. A lot of owners, after they have repaid the mortgage, they do not want to get the deeds back because they have to safekeep them. And there aren't enough safes to be provided by the banks. The safes aren't big enough, and there is not enough supply of safes, so that deeds could not be kept properly by owners. And there are also issues to be dealt with in relation to estate properties. There are also unhealthy competition because of the fees to be charged by solicitors. Every time there is a property transaction, solicitors as well as banks have to check the relevant historical records that date back to at least 15 years ago to make sure that the title is clean. Just now, Mr. Andrew Lam mentioned that some lawyers saw deceased insect bodies in old documents. I was one of these lawyers. That's why I did not take part in the relevant work. And this also has to do with auditing work. What is ironic is that because of these problems, we didn't see the Land Titles Bill put into operation back in 2004. Now, and concerning risks of impersonating owners, currently under the existing system, owners could take an oath to get a replacement of their deeds. However, some people may impersonate the owners, and without the knowledge of banks, banks may approve the relevant mortgages, and such kind of fraudulent activities occur from time to time. And this causes losses to the owners or the real owners. That shows that the existing deeds registration system should not be retained. The original plan was that by the second half of 2027, the government would review the existing registration system. I'm glad that the government is undertaking to, starting from 2026, explore with relevant stakeholders a conversion mechanism. As mentioned, there will be a phased approach. For land that is recently granted, they will be covered under the new system. For example, the new system may cover land that was granted about 20 years ago. Also, there could be a mandatory approach. According to the studies done by the Land Registry, there is relevant data concerning land titles. For flats that do not see any titles problems, they could be covered under the new system in a mandatory approach. Thirdly, we can rely on owners to voluntarily take part in the conversion. Of course, relevant checks will have to be done to ensure that owners could take part in the voluntary mechanism. Deputy President, another proposal that deserves our study is that the land registrar mentioned that we could set up an checking unit or working group. We can learn from other jurisdictions so that the checking unit will not have any conflicts of interest with the relevant stakeholders. For example, will law firms not willing to take part in the audit check because they took part in the relevant problematic property transactions? I think the government should invite people in a neutral position to take part in the checking work. For example, retired real estate sector practitioners or retired judges, so that we can dovetail with the international community by rolling out the new system. These are just ideas floated by me, and I hope the government will show the determination to make a breakthrough. After the passage of the bill, the government should come up with a timetable as well as a proposal to convert to the new system as soon as possible. The land registration system reflects the public management and administration level of a place, so we have to move with the times. President Xi Jinping, in his important speech on the 1st of July, clearly stated that we should, in a stable and proactive manner, make breakthroughs. So we have to provide certainties as soon as possible for the new system to lower costs and streamline procedures. These are all great measures that will benefit our people. I hope that the government will make breakthroughs as soon as possible and table the 6 pieces of subsidiary legislation so that we can have a timetable for the conversion mechanism. I so submit. Thank you. Ms. Eunice Yong. Deputy President, I speak in support of the registration of titles and land miscellaneous amendments Bill 2025. The existing land registration system relies on the deeds registration. This provides for basic safeguards for property transactions. However, title is established by checking previous title deeds, and therefore, property owners still have to bear risks during the transaction. With more and more property transactions and with greater transparency of information and high expectation on safety, this registration system no longer serves people's needs. Therefore, this bill proposes the titles registration system, with titles being the conclusive evidence to properties. And this is to ensure clean titles and to avoid relevant disputes. This reform will enhance safeguard for property transaction, and we will be able to meet international standards and benefit people by safeguarding their rights. Digitalizing the search process is one key of this bill. And in the past, for searches, we relied on paper form documents, and the relevant procedure was cumbersome, and it was easy for us to make mistakes by relying on paper form documents. we want higher efficiency, and so by establishing an electronic search platform, it will allow real estate agents as well as relevant financial institutions to obtain information more quickly and with greater transparency. The government learned from experiences of other places and came up with the identity authentication system as well as encrypted procedures to track historical records and to prevent unsafe access and storage of documents. All these designs help ensure safety of the public and help secure personal privacy. And this is also a way to reflect e-government services. Mr. Edward Lau just now mentioned about adverse possession, and the paper from the government talks about how we can complete the registration system. There was legal basis for adverse possession, but the relevant registration was not transparent enough, and so owners found it difficult to realize that the land concerned was adversely possessed. So with digitalization, we can have a glance of all the records easily, and this will also facilitate searches done by solicitors. To apply for adverse possession, of course, we have to go through a set of stringent procedures. We have to provide enough evidence for land registry to ensure that the application is fair and impartial. And the design of the system is to allow original owners to make counter proposals and to object to the applications. Digitalization will help ensure that everything will be done transparently and nothing will be done under the table. Under the new search system, there would be fair applications concerning rural land, and it will help enhance the efficiency of dealing with disputes. Some members of the public are concerned whether digitalization will affect personal privacy. Indeed, to do these searches, you have to verify your identity, and you will be subject to stringent regulation. And there should be a safe auditing system to deal with any potential leakage of information. I think we have to strike the right balance here. I hope that the government will continue to improve the system to boost people's confidence in it. For existing deeds, we have to digitalize it, and that's one major concern of the public. Some members asked whether the existing deeds will be replaced and be converted to the new titles registration system. I hope the government will adopt a phased approach and digitalize or to turn these deeds into electronic form. The government already said that there will be a transitional arrangement and provide technical support to owners and solicitors as well as real estate agents to make sure that they will be familiar with the new system. The bill proposes that all newly signed deeds should be registered electronically so that we can have both the old and new systems in place at the same time to protect owners' safety and risk and rights. Some are worried whether elderly people or those who are not familiar with using computers will have problems with searches. The government undertook to provide hotline services and counseling support. It will also hold educational campaigns as well as publicity campaigns to help those in need, and this shows that the government is adopting a people-oriented approach. We are turning Hong Kong into a smart city, so the new search system will be connected with other electronic platforms. For example, it should be connected with a system that deals with taxation and buildings approval, as well as a mortgage system of financial institutions. This will help boost efficiency, and it will reinforce our status as an international financial center. There have been some new digital asset products or real-world asset, RWA. So in a lot of places, real estate or property or IP are tokenized. I think with this new system in place, we can explore how we can digitalize different types of assets in Hong Kong, and then we can cement our status as an international financial center. We can also then think about how to roll out more financial products. As a lawyer, I am concerned whether there will be challenges faced by solicitors during searches. For example, paper form documents may be lost, and searches might not be able to be done immediately. With the new system, all these problems can be dealt with, and this can help ensure the professionalism of services provided by solicitors. For deeds of old buildings, I think if there are enough resources, we should promote the digitalization of these old deeds to bring benefits to people. I so submit.
Mr. Stanley. Thank you, Chair. Thank you, Deputy President. I speak on behalf of the FDU for our support of the bill. We have different measures of the government in land and housing. The current government takes a head-on approach to tackle a persistent issue since 2004, starting with new land that there's not much dispute on, and then moving on to existing land. It shows the government is pragmatic in taking forward the relevant arrangements. Making use of the land title registration system will bring about different benefits. One is that only a title certificate from the lands registry will be able to prove ownership. And in the title records, one can see very clearly the chain of ownership. In future, solicitors do not need to take much time in checking the titles. This new system tackles the root cause of the problem of adverse possession, minimizing the costs brought about by potential litigation. With the increase in efficiency of property transactions and land registration, that should reduce costs and drive more property transactions. With the passage of the bill, we will have the first batch of land exercising the new system, most likely to be in the Northern Metropolis. In the government's publicity campaign, I hope that the government can also promote the development opportunities in the Northern Metropolis alongside advertising for the new arrangements. This bill applies to new land. And there are multiple measures in the bill, or multiple proposals in the bill, in particular on those who lost their titles due to fraud, how they are going to be compensated. Before, the court had the power to hand down a rectification order to have the property returned to the original property owner. This bill, on the other hand, has the principle of indefeasible title. If the title is involved in fraud, there are 3 conditions to be met. 1, the purchaser has to be acting in good faith and be without notice. they have to have provided available consideration, and they need to be in possession of the property that, with the 3 conditions met, the purchaser will have indefeasible title. So we have quite a high threshold here for the original property owner to lose their title. I hope the administration will publicize the relevant arrangements to instill confidence in the public. On top of publicity and education, I also have some suggestions for the land registry. We should make good use of anti-forgery features and blockchain to ensure the integrity of paper documents. The lands registry should provide free property gatekeeping services. Notifications are set to be issued to owners now, but we have to understand some owners may not be able to deal with emails or SMSs if they have migrated or if they have other issues. We should give enough facilitation to owners so that they can be notified. The registry may also consider inviting the owner to the registry for procedures so as to prevent the owner from losing their title without notice. And the registry should explain their policy well and set up a mechanism for providing compensation to complainants if necessary. We want to expedite conversion of existing land. I urge the registry to hasten their pace of conducting the in-house research so that they can get a better understanding of the situation. If we can provide additional protection of the owner, that will be beneficial. So we hope that the government would heed our feedback. On minority or incomplete ownership, the owner should be notified. For some traditional cases, such as those involving Chotong or Qing Dynasty land or New Territories land with old arrangements, we should provide outreach support services to the owners. With the commencement of the bill, we will enter a new chapter, moving on to the land title registration system that will have our standards aligned with international standards. It will provide also better certainty for owners and offer them protection. On the indemnity mechanism, I think as long as the government acts as a gatekeeper and prevents property fraud at source, we should not have to claim from the fund much. I so submit. Mr. Holden Chow. Deputy President, I speak in support of the Registration of Titles and Land Miscellaneous Amendments Bill 2025. I have heard many members talk about the policy intent of the bill. As a legal practitioner, I want to speak on behalf of practitioners. Some may ask, why is it that not many law firms deal with property transactions in Hong Kong? It is because, as many members mentioned, one has to check the title 15 years beforehand, and one cannot really charge high fees for doing so. The bill will focus on new land, and then the next step will depend on implementation of the bill. I think it's a pragmatic approach. With the arrangements, however, it would have already alleviated the burden on practitioners in checking titles. It will also make it easier in general. So for the legal sector or for anyone dealing with property transactions in the city, it should help. However, I want to share with you some observations I had before so that we can potentially iron out some issues now before the bill is actually implemented. I have heard many citizens saying they have lost their deeds for various reasons. It's probably because they lost the deeds on their own negligence. But then if you have dealt with the relevant transactions before, you should know if you want to, say, apply for a mortgage from a bank, the bank is not willing to grant your application if you don't have a deed. So let me say again, this bill would focus on new land. With this new registration system, is it the case that we won't see or will see situations in which, with one having lost the deeds, they would no longer be able to apply for a mortgage? Can we fix this? That's my question. I hope this Bureau can address this question in their reply in due course. I am not a member of the Bills Committee, but I note the records of the Bills Committee saying that the Legal Services Division has written to the administration asking about resulting trust, which is something that many legal practitioners should be familiar with. These are unregistered interests. The Legal Services Division mentioned this issue, and the administration has provided a reply. I would like to, however, ask the administration to spell out in their reply in due course how they will deal with resulting trust. I think apart from providing a proper reply to the Legal Services Division, it offers an opportunity for the administration to make clear their stance. I do support the amendments, but let me say also that solicitors have a duty, and in future there will be guidelines on verification requirements for solicitors. I appreciate that. I so submit.
Mr. Lee Chen-keung. Thank you, Deputy President. The Liberal Party and myself support the passage of the Registration of Titles and Land Miscellaneous Amendments Bill 2025. The bill seeks to amend the Land Titles Ordinance, which was enacted in 2004, which has not yet come into operation. The bill, the LTO involves introducing a title registration system for 2.9 million titles in Hong Kong. Well, no consensus could be forged among stakeholders, and the LTO has yet come into operation. We remain stuck with the deeds registration system. We believe that we need to catch up with the international trend, and we need to take a pragmatic approach and go for the low-hanging fruit to resolve the 20-year-old problem. According to the amendment bill, the title registration system will first apply to new land. As for existing titles on the existing land, they will go by the deeds registration system for now. Now, I think for the general public, there is no clear distinction between title registration and deeds registration. However, for purchases of properties in Hong Kong, UK, and the mainland, they would surely know the vast differences between the two systems. The experience is, of course, still fresh in their minds. For property buyers in Hong Kong, they need to entrust a solicitor to inspect the deeds. Now we're talking about a whole bundle of deeds and historical documents with the traditional typesetting of a typewriter. The bundle may also be strewn with the dead bodies of insects. The inspection involves checking any unregistered interests of a third party, and the process is very complex and cumbersome. It's also prone to problems. And when the property is resold, the whole process will need to will happen again. And this is costly, and it's also a waste of resources without ascertaining the title. Whereas if you buy a property in the mainland or in UK, they go by the title registration system. The title in the title register should prevail, and there is no need to check other records. So it saves costs and manpower resources. In the mainland, upon completion of the conveyancing process, a certificate will be issued to the buyer. It's really reassuring. It makes the process much simpler. So for Hong Kong buyers who have bought properties in the mainland, surely they understand the merits of the title registration system. The bill seeks to introduce the title registration system similar to those in the UK or in the mainland, so as to benefit both parties of the transaction as well as the society in general. The land legislation in Hong Kong was enacted in 1843 by the British colonial government. The LTO was enacted in 1844 to provide, the LRO was enacted in 1844 to provide legal backing for land transactions. In 1862, however, the UK took a different approach. The land registry was set up and a voluntary title registration system was put in place, and starting from 1925, the system had been implemented in phases. Now the title registration system has become an international trend. Hong Kong, along with places such as France and Belgium, are some of the few places that are still stuck with the deeds registration system. In fact, in the 1990s, the British colonial government tried to enact legislation to implement title registration system that failed. In 2004, the SAR government gave up on the idea of a conversion overnight, and instead a phased approach would be taken in registering titles. However, there was a lack of consensus among stakeholders at the scrutiny stage. The SAR government quite reluctantly adopted the Law Society's proposal of the so-called daytime reform. Then complex amendments were made to the ordinance. Still, there was no consensus among stakeholders, and it's been 20 years. President, simply put, we cannot introduce the title registration system overnight. We need to try it out first. It's a smart choice to do it this way. For existing land, we'll go by the deeds registration system until we find a way out. This is in fact the only option for starting to implement the title registration system. We need to make a start and go for the low-hanging fruit. We need to make a start in order to gain experience. There are substantial changes to the LTO in other aspects, such as abolition of the mandatory rectification rule, as well as the infeasible title principle for property buyers, bona fide purchaser for valuable consideration and in possession of the property. In the event of being defrauded, they will still enjoy indefeasible title. As for the original owner, he will not be able to regain title, and he will be compensated according to the indemnity fund to be set up. There are also safeguard measures in the bill to prevent fraud. For example, a certificate of verification should be issued by the solicitor concerned. There should also be a certificate issued to the owner. And if a rectification is needed, then one should apply to the court for this order. And for suspected frauds, one can apply with the court for a prohibition or restriction order to be made to prohibit the registration of title. There are also offense provisions. Now, we've gone through so many hurdles, President. Now we have found a solution. This may not be perfect, but time will tell. This is hard to come by. The Liberal Party supports the passage of the bill. Mr. Louis Long. Deputy President, my friend, who is a solicitor, once told me that the title registration system only exists in a perfect world. In this utopia, the principle that the title register prevails. The registered title is indefeasible. It is not revocable. In Hong Kong, at the moment, we practice the deeds registration system without guarantee of title of the property. So before each property transaction, the seller should provide proof, documentary proof of up to 15 years of historical records. Even for a small flat, an owner will need to prepare stacks of documents. Imagine it's about a big piece of land. And if you lose the documents, it will be difficult to sell the flat or apply for mortgage. In July 2004, the Legislative Council passed the Land Titles Ordinance, and that the title registered will be the conclusive evidence. There is no need in theory to check the deeds again. There would be clarity and certainty in the conveyancing process. Still, 20 years on, the LTO has not yet come into operation, and that is because we don't live in a perfect world. This is also well understood by the Legislative Council as well as the government. Back then, there was an undertaking that upon operation of the new law, a comprehensive review will be conducted. There will also be another round of consultation with key stakeholders. And as a result, the Land Registry set up the LTO Steering Committee comprising representatives of key stakeholders. Now, I have been a member of this steering committee since November 2004. There had been 5 different directors, and I have been participating in the process, and after years of deliberations and studies, the steering committee finally concluded its study on this bill, which is the Registration of Titles and Land Miscellaneous Amendments Bill 2025. The original proposal was to convert the system overnight. Now the government has decided to go for the low-hanging fruit first, and upon commencement of the bill, the title registration system will apply first and foremost to new land. I believe this is a pragmatic solution, so I support the new land first approach. I represent the REDA, Real Estate Developers Association. Unfortunately, in 2004, REDA strived to offer greater protection to innocent owners in the event of fraud, and we strived to establish the mandatory rectification rule. And it is unfortunate that through this bill, this rule will be abolished. The new owner will enjoy indefeasible title even in the event of fraud. The amount of indemnity will be increased from $30,000 in 2004 to $50 million. According to the government, it covers 99% of property transactions. Still, it doesn't change the fact that 1% of the interest will be compromised. Now, for commercial properties, the transaction volume may not be comparable to residential property transactions, but the transaction amount could be astronomical. I once urged the administration to consider setting a high cap for commercial property transactions with higher levy rates. The government, however, believes that this will add to the complexity of the system, not to mention the administrative cost. Now, it's not so much as providing additional safeguard to commercial property buyers. It is important, however, that we let international investors know that their interests are safeguarded and that Hong Kong still welcomes investors. My suggestion has not been taken on board by the administration. I hope with the commencement of the new system and after acquiring experience and collecting data, the government would conduct a review on the levy rate, including that for commercial properties, and the possibility of setting a higher cap and a higher levy rate for commercial properties so as to improve this imperfect system. One important amendment to be proposed today is that with the consent of the registrar, for redevelopment projects on new land, the developer can opt for deeds registration system. Now, before this bill was floated, the government's original proposal was that for these kind of redevelopments, the new system should prevail. Otherwise, only separate developments will be allowed on separate lots. Now, there was a backlash in my sector. For private developers or even the URA, very often they would put small parcels of land together so that they could increase plot ratio in the comprehensive project. According to the original proposal of the government, only standalone buildings could be developed on individual sites. The government should be innovative. The government should also remove red tape. The government should consider the people first. Even if 99% of users could benefit more from the new system, I still believe that we should take care of the remaining 1%, and there should be a way out for them too. I had a number of meetings with the administration, with a view to finding a solution. I'm happy to learn that the Development Bureau and the Land Registry have heeded our views, and that through a committee stage amendment, this exclusion mechanism will be formulated. During the scrutiny of the bill, I proposed a further relaxation for owner of 2 adjoining lots to be excluded so as to unleash potential. President, this bill will introduce the title registration system. This is the fruit of hard labor of the steering committee as well as the Bills committee, and it has taken a very long time to bring about this success. Just like the story of Niger, I hope that this bill will be as good as Niger. At the same time, the government should step up public education and publicity to enhance the understanding of this new system by the sector. There should also be public education so as to enlighten the public about their rights. With more experience and more data available, the government should start discussion with stakeholders on the conversion of the 2.9 titles on existing land. I support the bill. I'm going to support the amendments as well.
Ms. Doreen Kong, Deputy President, I speak in support of the registration of titles and land miscellaneous amendments Bill 2025. The existing land registration system in Hong Kong was set up in 1844. It's been in use for over 180 years. This deed registration system has grown with Hong Kong. This system has its merits as well as stability. However, with the property development in Hong Kong and with higher expectation from the public in 2004, we had the Land Titles Bill. We hoped to have a system that features indefeasible titles. However, over the past 20 years, because of various reasons, the bill could not be realized. Some people may wonder why we couldn't put the bill into operation over the past 2 decades. I agree with what Mr. Lewis Long said. We're not in a perfect world. As a lawyer and as a member of the Property Committee of the Law Society of Hong Kong, I see that the government as well as the relevant stakeholders have been working very hard to see how we can implement the bill. However, the titles here in Hong Kong, they incur more complicated issues compared to those in other places. We have to look at the right of easement as well as adverse possession, and it's hard for us to strike a balance among different stakeholders. The new system will cover new land first, that is, land granted after the commencement date of the bill. I think this is a doable proposal. This is because newly granted land will involve less complicated titles problems, and the new system can serve as a pilot for the government to comprehensively assess the feasibility of fully implementing the new system. For newly granted land, as long as it meets the relevant requirements, for example, the buyer has to be bona fide and it acquires a property for valuable consideration, and then the owner will be able to enjoy indefeasible titles. There will be an indemnity fund, and the indemnity cap will be increased from $30 million to $50 million. The government is in a rather tight fiscal position. I think in the short run it's hard to further increase the indemnity cap, but I hope that in the long run the government will continue to monitor the market situation. When necessary, the government will hopefully review the indemnity cap so that owners will not suffer any losses under the new system. Mr. Edward Lau mentioned about possibilities of property frauds. I'm glad that the government has taken on board the suggestions made by the Law Society. Under the new system, a new certificate will be issued to new owners with anti-forgery features. This will help lawyers identify genuine owners, and this will help protect purchasers as well. Also, under the new Land First proposal, there might be restrictions to conducting searches on titles. This is different from the existing system. Titles documents are complicated, And some of the titles, they are traceable, and the historical records concerned might serve certain reference value. I hope the government will make sure that we have an open and transparent system. Here, I'd like to thank members of the Property Committee of the Law Society of Hong Kong for their dedication as well as professional contribution, and as well as their comments on the bill. This helps us scrutinize the bill, and a lot of them are experienced lawyers. They put aside their own interests, and solely from the perspective of the feasibility of the system, they provided their professional views, which is very valuable. Some comments made by the Law Society are not covered under this bill. I hope that upon the implementation of the new system, the government will maintain communication with the relevant parties and take on board the relevant comments and views. Lawyers are very concerned about the details of the bill. After the scrutiny work is completed, we continued to receive letters from the legal sector as well as the Law Society. It shows that they are very concerned about the new system. They are concerned about the status of charges made under an agreement, as well as the provisional sales and purchase agreement. I hope the government will continue to collect views from the sector after the passage of the bill. Under the new system, we will see the coexistence of the the deeds registration system as well as the title registration system. This is not something new. There are precedents in other places. What matters is the government will devote enough resources for education and publicity. After the revision of the bill will contain several hundreds of pages. For members of the public as well as overseas investors, this piece of document may not be easy to digest. I hope the government will adopt a phased approach as it launches the publicity campaign. I hope that it will use easy-to-understand approach to allow people to have a better understanding of the bill. This bill is not an easy or straightforward one. There are many technical details in the bill. I appreciate the courage and the determination of the current term government to revive the bill and the new system. Mr. Lee Tek-wei, one of the lawyers, offered his valuable comments, and he is here today. I believe that members of the committee were under pressure during the scrutiny. Well, I'm not scared of dead insects. And I have seen many old documents which have turned yellow. While this current system is criticized to be an outdated one, the deeds registration system has witnessed the history of Hong Kong. When I joined the legal sector in the 1990s, there were already discussions about having a new system. I can't imagine that I'm now in my 50s and we're discussing this bill that proposes to implement the new system. It's been 30 years and finally we're making the step to implement the new system. I give my 200% support to this bill. This is because we have to move with the times. I so submit. Thank you. Mr. Paul Che. Ms. Doreen Kong said she gives her 200% support to this bill, and I give my 1000% support. This is because I joined the legal sector 30 years ago. I do not mind reading papers, but I always resist reading deeds, so I'm not a lawyer specialized in property transactions. This is because it is a very time-consuming work. We have so many professionals in Hong Kong who've spent so much time on explaining the deeds and relevant documents to the transaction parties, and this does no one any good. This is not productive, and this is a waste of resources, but this is necessary in order to safeguard the interests and rights of the transaction parties. So I believe that this bill is a mission impossible. Well, at least it was considered as a mission impossible in the past. Over the past few weeks, the government has experienced a lot. For example, for the waste charging scheme, the government gave up on it. So this is a loss that I considered on the government side. And 2 weeks ago, we had the registration of same-sex partnerships bill. Despite all the challenges, the government introduced its bill to this council. And I would say that it was an even, because the government saw no loss. And the government is seeing a win or a victory today because it's been 20 years. Well, actually more than 20 years, because the Land Titles Bill was established in 2004, and the Law Reform Commission had been pushing for this, and we never managed to materialize it. In this legislative session, we see this registration of titles and land bill, and we also have the harbor protection bill. And for these two bills, I think we managed to overcome the hurdles and strike a balance. For this particular bill, I give my 1000% support, and I totally agree that there is a need to have this bill. Mr. Martin Liao, as the convener, said we should do away with the details. In fact, we have already gone through the details as well as the technical parts of the bill at the Bills Committee stage. So I just want to recognize again the Secretary's effort in promoting this bill. I think the legal sector shouldn't be too worried, because over the past few years it's been hard to recruit lawyers to engage in property transactions, because many of them find it very time consuming and they don't know when the system will change, so they're unwilling to take part in the relevant work. So I'm glad that we're finally seeing an improvement here. Also, there are people who are hesitant about joining the legal industry because they are afraid that AI would replace them. So I think we're moving with times here.
Mr. Lam San-kang, thank you, Deputy President. For this bill, I would like to express my support for the administration's new initiatives in land in general, but for this bill, I actually have some reservations. It is because there are some issues that have been identified. The government has yet to address them properly. They cannot provide answers specifically. But I guess we can't really just blame the government. They have already taken an important step to move on from the old system, but they have much to do still. There are difficulties in implementing this bill. To facilitate people's understanding, I can elaborate on this. This is an amendment bill. The original legislation was passed in 2004, but it has yet to come into operation. Since 1925, the UK has reformed the land title registration system, and they have been doing it for 100 years. The Law Society of Hong Kong has been advocating for this. They have, and I have raised questions 3 times on this, and my last letter was on 19th of August, and I only received a reply a few days ago. I did receive a reply, but the government has yet to properly address my questions. Yesterday, 24th of September, we had a super typhoon. The government responsibly addressed the questions raised by the Law Society of Hong Kong in their letter. I appreciate their attitude. I think it is really difficult to have a comprehensive solution to the different issues involving land policy. We have for 180 years a colonial era system for deeds registration. There are many issues with this system. The government only does work in registration. They do not do any work of checking. That responsibility is with solicitors. And solicitors have to check titles. If they are wrong in any way, they are held accountable. And honestly, for conveyancing transactions, they can't charge a lot, so they are losing every transaction. And for law firms, most of them are sole proprietorships or partnerships, unlimited partnerships, so they will be held accountable. Their partners will also be held accountable. It is not beneficial for the development of the sector because they do not want to go into such transactions. So I do support the use of land title registration system to enhance efficiency. This new system is supposed to replace the deeds registration system and to provide for indefeasible titles. The approach is the title register should prevail, making property transactions much simpler than before. This amendment bill also provides better protection for owners affected by fraud. If we pass the amendments today, I hope the government will identify any issues in implementation early on and make adjustments as soon as possible. The sector has reservations due to the following issues. When confirming an indefeasible title, there is a condition on whether the purchaser is acting in good faith. That has to be verified. Let me give you an example. So, an owner, the day before, sold the property to two buyers, and the letter registered the consent caution first. Who owns the property? The reply given by the administration to the Law Society's letter yesterday is that who comes to register will be regarded as the owner. So even when one signs the contract first, it doesn't make you the owner. This is different from the existing system. Right now, it doesn't matter who signs the agreement first. Within a month, if they're signed within a month, the one who signed the agreement first will be the owner. So I hope solicitors note this. Otherwise, you may very likely make a mistake. We have property transactions done by different parties in Hong Kong, investors, general property buyers. We have different circumstances in reality. If the bill is passed, I hope the government attempts to anticipate the different scenarios. And if you observe scenarios that you have not anticipated, you should follow up on them as soon as possible. We adopt a new land first approach. This essentially gives a transitional period for the market. And I think we should make sure to expedite conversion of existing land as soon as possible. I so submit. Dr. Junius Ho. In the legal sector, we have many risks. Before the passage of Chapter 585, lawyers are held accountable for a lot of things. Therefore, we have insurance taken out for indemnification of professional liabilities. One of the major areas is in property transactions. Before, we had a scale of charges. Depending on different workload, we will have different fees. Before 1997, we have the scale charge. So lawyers were still willing to do conveyancing work. Basically, they are responsible for being held accountable with that charge. But after 1997, we no longer have this surcharge. So lawyers charge a meager fee, but they are held liable for over $10 million. So the solicitors may be held personally accountable for any amount beyond the indemnification. Property agents will sign temporary agreements, and then the agreements will be handed over to solicitors. And then the solicitors will be held accountable. So for property agents, they can receive $200,000 in commission if the property is $10 million. But the solicitors don't charge much, but they are held accountable. And their operations are associated with higher risks. Ms. Doreen Kong expressed her full support. Mr. Porter said he supports this 1,000%, and I would say I support this 10,000%. I don't understand why it took the administration 27 years. For 27 years, the ordinance did not actually commence. All along, solicitors had to bear excessive risks. They provide registration services, but then registration does not mean someone actually owns the property. So solicitors in the end are often made accountable. Right now we have this registration of titles and land rather than just the land titles ordinance. So solicitors charge a meager fee and are held accountable. They have already accepted that. But with this land title registration system replacing the old system, the difference is the administration is now held accountable. So in future, people may not even need to engage solicitors. Who says one is an owner? It would be the government in future. So if the owner is not actually the owner, who is held accountable? The government. Right now, the administration wants to shirk this responsibility back to the solicitors. So they think since the solicitors have insurance, they should be held accountable. And there were disagreements for, say, 20 odd years. Finally, we're making progress, and the indemnification cap was increased to $50 million, and it is said to cover 99% of the transactions, which is appreciated, but there's still a problem. There may still be the possibility that solicitors may not be engaged in future at all. They will only have property agents doing relevant work. So who will be the gatekeeper in future without solicitors being held accountable? I think the government officials are quite scared. But let me say this, we are moving on, and that is appreciated. The bill would focus on new land, and I also appreciate there is an increase in indemnity cap. But then I note there is an issue with New Territories land, that we had the Japanese burning down houses, so there is confusion about the ownership. I would say this, the government should not do unnecessary things. You want to streamline the process, and you should be held accountable. You are advocating for this, so you should be made accountable. In the past 21 years, the government has been advocating for the new system, but they don't want to take the responsibility. So they asked Dr. Junius Ho, Mr. Lam Sen Kung, solicitors like us to cover for them. But as I said earlier, the charges charged by solicitors are much lower than what it was before 1997. We're only charging $4,000 to $5,000 for a $10 million property, but we are taking risks for the $10 million property. It does not make sense. So I would say perhaps we should have, on top of registering the interests, we should make it easy for legal practitioners. You are only giving solicitors a small incentive, but we are held accountable for very big risks. It has been many years since 1997. I was not on the Bills committee, but I want to speak on behalf of the legal sector. We should establish the scale charge again. If you're asking us to pay insurance premiums, but we cannot recover the relevant costs when we are asked to be held accountable, it does not make sense. So I think in the end, the government should bear the relevant costs. There is not much fraud risk associated with solicitors, so I think you can bear the relevant costs. Like I said, I think you should introduce the scale charge again for the healthy development of the legal sector.
Does any other member wish to speak? If not, I now call upon the Secretary for Development to reply, then the debate will come to a close. Secretary. Deputy President, I thank the members who have spoken in this resumption of second reading debate in support of the registration of title and lands miscellaneous amendments bill. The bill seeks to gradually replace the deeds registration system, which has been in place in Hong Kong over 180 years, with a title registration system. Hong Kong is among the few economies that still use a deeds registration system. The current system does not provide a guarantee of property title. As a result, thorough examination of historical title documents is required during property conveyancing to ascertain title, making the transaction process complicated and lengthy. Property owners must also ensure proper safekeeping of title documents. In 2004, the government enacted the Land Titles Ordinance to replace the deeds registration system with a title registration system. However, due to the complexity of implementation details and the lack of consensus on key issues among stakeholders, the ordinance has yet to come into operation. To expedite implementation, the government proposes to go for the low-hanging fruit first, and that is the new land first approach, whereby the title registration system will first be applied to new land, with conversion of existing land to be dealt with separately after in the next phase. So what does new land mean? It generally refers to land granted by way of land sale, private treaty grant, or land exchange on or after the commencement date of the ordinance. The government has widely consulted stakeholders on the new land first proposal. The proposal has received unanimous support from the Land Titles Ordinance Steering Committee, chaired by the Land Registrar, and comprising representatives from the legal, banking, real estate, and rural sectors. We also consulted the Legislative Council Panel on Development in December 2022 and January 2025, both of which expressed general support. So in February this year, the government introduced a bill into the Council to amend the Land Titles Ordinance. The bill also provides for consequential amendments to over 70 other ordinances. I'd like to sincerely thank the Bills Committee Chairman, Mr. Edward Lau, Deputy Chair, Ms. Doreen Kong, all committee members, the LegCo Secretariat, legal advisors, the Department of Justice, as well as my colleagues and colleagues from the Land Registry for their tireless efforts, which have enabled the smooth completion of the scrutiny work. This bill is in fact not straightforward at all. It's very complex. The Bills Committee commenced work in April this year and completed the scrutiny in July. 7 meetings, including a public hearing, were held. The public hearing was attended by professional bodies such as the Law Society of Hong Kong and the Hong Kong Institute of Surveyors. The Law Society submitted 3 written submissions to the Bills Committee, all of which were responded by us in great detail. And during the deliberations, members had in-depth discussions and examination over 600 pages of the bill. They offered many valuable suggestions. And apart from that, members and chair of the Bills Committee also continued to communicate with their respective stakeholders using their own network. I really appreciate their efforts. After careful consideration, the government has adopted a number of suggestions. I will explain those in greater detail at the committee stage. Now, I'm sure that all of you are well aware of the content of the bill, but let me go through the key features as follows. The first feature is the principle of indefeasible title. Under the title registration system, the title register is conclusive evidence of the title. This principle is one that allows the title register to prevail. So even if a property transaction involves loss of the deeds or loss of other documents, it will not prevent the owner from proving its title. And if the property transaction involves a fraud by a third party, a bona fide purchaser or value in possession of the property without notice still enjoys indefeasible title. This is consistent with the principle that the title register prevails and this owner enjoys indefeasible title. This is in line with the similar arrangements in other jurisdictions. As for the original owner who loses the property without notice, they will be entitled to compensation from the Land Titles Indemnity Fund. The system also seeks to provide certainty of title. The bill proposes that adverse possession claims will not be accepted for new land. During the deliberations of the Bills Committee, we find that there is support for this arrangement. The members also urge the administration to explore the handling of adverse possession claims for existing land as quickly as possible to avoid unlawful occupation of land. And we will actively explore another comprehensive approach on handling such claims. Now, the second feature is reducing the risk of property fraud. Some members expressed concern about mechanisms to prevent property fraud under the new system. The bill proposes a number of measures to mitigate the risk of fraud, including a solicitor's certificate of verification for registration applications, issuing title certificates with advanced anti-forgery features to property owners by the land registry, and requiring a court's ratification order before making a claim against the indemnity fund, empowering the registrar to issue restriction orders to prohibit registration where there is reasonable suspicion of property fraud. Also, it is provided that fraudulent registration or indemnity claims constitute a criminal offense. The third feature is arrangements for rectification and indemnity. Making reference to other jurisdictions, we follow the user pays principle established under the Land Titles Ordinance. A self-financing indemnity fund would be set up to provide compensation subject to a cap to persons who lose title due to a third-party fraud. The government proposes a levy rate of 0.014% across the board for each property transfer. That is $140 per $1 million of property value, capped at $7,000. The indemnity cap is set at $50 million. We expect to fully cover over 99% of property transactions. The levy and indemnity arrangements will only apply to property transactions involving land registered under the new title registration system in the future. As for the indemnity rate and the levy rate, they are easy to understand. We don't want to introduce a tiered system for varying values of property transactions, and this is supported by the Bills Committee. Another point is about rectification for mistakes and omission. The bill empowers the registrar to rectify errors or omissions in the title register, and the court may order such in these cases. We're going to move some amendments, and I will explain them when I move the committee stage amendments. As for details of the procedures, they will be set out in the subsidiary legislation to be submitted to the Legislative Council. After consulting stakeholders, we will submit the subsidiary legislation to LegCo in 2026. The next point is about publicity and education. Some members are concerned about solicitors' responsibilities under the new system. They believe that solicitors will need to adapt to the new system, and the bill proposes that if a solicitor acting in good faith and with reasonable care in verifying applications, he will not be liable for any loss arising from any error in the verification process. The standard of reasonable care is widely adopted under the common law system. It is also the standard required of solicitors in current conveyancing transactions. For overseas practitioners under the title registration system, they also follow similar standards. The Land Registry has drafted guidelines to assist solicitors in fulfilling their verification duties, and we will continue to engage with the profession to explain to them the guidelines to help them become familiar with the new system. The Bills Committee is also concerned about the public understanding of the principle that the title register shall prevail. The committee believes the government should strengthen communication. Now, we've established a title registration education committee with key stakeholders to coordinate and oversee public education and publicity campaigns about 6 months before implementation. We will continue to mount publicity to ensure that the public and the industry have sufficient time to understand and adapt to the features and operation of the new system. Some members just now referred to the inspection of the register. Now, in terms of the arrangement, we go by the established principles, that is to strike a balance between safeguarding personal data privacy as well as facilitating the inspection of the register and maintaining market transparency. We want to create a favorable environment for the sector whilst facilitating the inspection of the register. We're going to stipulate the details in the subsidiary legislation after consulting stakeholders. The subsidiary legislation will be submitted to the LegCo for scrutiny. Now, one key issue in the deliberations process is when this system will apply to existing land. The government adopts a progressive approach to expedite the implementation of the title registration system. Implementing the system for new land first will allow stakeholders to accumulate experience. It will also be conducive to extending the system to existing land in the future. Some members just now talked about overseas experience of parallel operation of the old and the new system. To achieve the ultimate goal of converting all existing land to the new system, the Land Registry has not relaxed its efforts. It has commenced an internal study to assess the scope and the types of problematic registers among the 2.9 million titles with a view to formulating the conversion proposals. We plan to commence discussions with the stakeholders next year on different options such as phased conversion, starting with the more recently granted land. We will also consider, for example, mandating conversion upon first transfer or assignment after the ordinance comes into effect, as well as voluntary applications for conversion. We will consult stakeholders on specific proposals starting from next year so as to find the most practical conversion solution. I urge members to support the bill as well as the various amendments which I will move at the committee stage. Should the bill be passed, the government plans to submit 6 pieces of subsidiary legislation covering application procedures, fees, levies, indemnity fund, court rules, electronic submissions, and other related matters. The subsidiary legislation will be submitted to LegCo under the negative vetting procedure. We'll also work with the industry and the public on public education and publicity with a view to bringing this bill into operation in the first half of 2027. This bill provides for the new title registration system, which will apply to new land only at this point. But as many members have pointed out, this is already a major milestone, it's a big leap forward. And it is also the result of a joint effort by the government, the Legislative Council, stakeholders, including the legal profession, the banking sector, property sector, etc. We have been able to make this stride because of the joint effort. I'd like to thank members for your support. You've given us 100, 200, 1,000 or even 1,000,000% support. And on top of that, other members have also uttered words of appreciation. Let me just say that this is indeed very encouraging for our team. Now, next year we're going to table into the Council other subsidiary legislation. I hope we'll continue to receive encouragement. With early passage of the bill, along with the amendments, we will be able to introduce the title registration system as early as possible so that we can enjoy the merits of the system. And this will also form a solid foundation for the gradual full implementation of the system in Hong Kong and start a new chapter on the land registration matters in Hong Kong. I now put the question to you that the registration of titles and land miscellaneous amendments bill 2025 be read the second time. Will those in favor please raise your hands? Those against, please raise your hands. I think the question is agreed by a majority of members present that declare the motion passed. Registration of titles and land miscellaneous amendments bill 2025. This